Move right along. So good afternoon, everybody. Welcome to the City Council hearing. In attendance, it looks like we have Councilwoman Danielle McCray, and it looks like we lost Councilman Robert Stokes, Councilman Bill Henry, Councilman Christopher Barnett, and we have from the Law Department, Victor Tavlo. We have from the Mayor's Office, Matt Stegman, Nina Thelmus, and who's staffing the committee. Of course, we have Sam Johnson. So thank you all for being here, and we can actually jump right into it. This bill is 20-0543, COVID-19 Employee Retention Bill for the purpose of requiring certain successor business employers taking control over certain businesses from incumbent businesses employers to retain certain employees, requiring that the incumbent business employer to provide the successor business employer with a list of certain employees, permitting a successor business employer from not retaining certain employees under certain circumstances, requiring the postings of the notice when certain businesses undergo a change in control, prohibiting retaliation against employees from seeking assistance from or cooperating with the Wage Commission, empowering the Wage Commission to issue subpoenas and administrative oath, establishing certain procedures for the administration of complaints by the Wage Commission, requiring certain reports, defining certain terms, establish certain penalties, and providing for a special effective date. This resolution was introduced on June 15th, 2020. It was sponsored by Councilman Chris Barnett. And now we can hear from the sponsor of the bill.
Thank you, Madam Chair and members of the committee. So I'll keep it brief because I have had an opportunity to speak with all of you about this legislation, but just for the record, so the legislation essentially focuses on transitions in ownership between businesses. So if there's a new owner that's taking over a company, a business in Baltimore City, similar to the Displaced Workers Act that you sponsored, Madam Chair, a few years back, it creates a 90-day transition employment period in which that successor business employer may not discharge the employee without just cause. Essentially, what we're trying to do here is, during the pandemic, there has been a lot of economic instability for both workers and employers. And the intention here is knowing that the instability may trigger substantial changes in ownership, especially in our tourism industry, our service industry, which have been deeply impacted. That there could be companies that go out of business, new company comes in, and to no fault of their own, employees are laid off. And so the intention of this is to the similar motivations to the Displaced Workers Bill, which focused on city contracts, extends that outward to certain types of employers, primarily tried to focus on low wage workers, to fully disclose that, just trying to make sure that we are protecting the folks who are the most vulnerable and giving them either an opportunity to prove themselves, which is ideal, right? I mean, all of these places are looking for workers to come back, who want to come back. And I've talked to property owners who are struggling right now to get employees to come back. And so knowing that there's been challenges on all sides, this is an attempt to create some stability for these employees to either find something new if the intention of that new owner is to liquidate and let go of everyone, or to prove themselves and show what they have to offer and that they're willing to work hard, especially under these very challenging times and circumstances that we're in. I do have a few amendments that I won't be offering today, but we'll talk to all of you in the committee about, mainly because a few of them we were just talking through like within the last hour. So I'm not ready yet. So my hope was for this hearing was to present the bill, hear back from the agencies, hear public testimony on all sides, and to continue to work with the law department and the advocates. Sorry for the background noise. The advocates to try and figure this out and make sure that we get it right before moving forward. So I'm not asking for a vote today. I do want more opportunity to work through it. Thank you, Madam Chair and committee members.
Thank you, Councilman. Before we go into agency reports, does anybody from the committee have any comments or questions? Nope. Oh, okay.
My comment is I'm here. Chair, I apologize. Thank you to my colleague, Councilman Henry, and whoever else helped. I've been here. I've just been, I can see you, but you can't see me. Thank you. And I did, in the course of the discussion, I'm presuming this bill applies also to contract workers in the subject or eligible establishment, that the contract employees are also covered by the provisions of the bill. You don't have to answer it now. Someplace in the discussion, just so I'm clear about that. It's fine. I think it's a good idea. It's just it's a question I have of how that works. Okay. Thanks. Thank you.
Thank you, Councilwoman. We'll just go right over to the law department. Victor, do you want to maybe address?
Sure. This bill is, this is Victor Overler from the City Law Department. The bill is so similar to the Displaced Service Workers Protection Law. It does protect a broader class of employees. The Displaced Service Workers Act really protected building service employers, which are like janitors and security officers, and food service workers. This actually regulates the employers of commercial property, of employees of commercial property, or event center employers, as well as the employees of hotels. So it's a little, there is some overlap between one and the other, between these two bills, but this is a broader bill than the Displaced Service Workers Act. And to the extent that they differ, we didn't see anything that was significant from a legal perspective of why we could not approve this bill for form and legal sufficiency.
So. Thank you for that. I didn't mean to interrupt the flow here. I just, when we get to the bill that ends in a 3, the one, you know, the callback, when ownership of an organization changes, the first bill is where I was asking about whether contractors, if I own a hotel and somebody buys it, then I have an obligation to make sure to hold on to the original employees for at least 90 days.
That would be correct.
And if I happen to be a contractor within that hotel that runs food service, I got my own company, but it's attached to that hotel. I'm a contractor. My employees are to get that same benefit, correct? You may not know the answer right now, but in the course of all this, if we could get the answer, it's just, I'm not opposed to that part of the bill. I think it's great. I just wonder the logistics of how it works. And I don't need to know them now.
I'd have to, Councilwoman, I'd have to know exactly what we have in the bill. I think
yeah, you got that.
Covered, but let me do
that. You have that under the first category. And it's good because they're the people that are generally forgotten. But I'm just wondering how it operates. So
if that contractor is a commercial property or event or a hotel employer, so if it falls under any one of those categories,
Yeah.
it would be regulated. And if they don't fall into those categories, then we're not going to catch them. So it depends on. I mean, it sort of depends on the business that we're talking about here. So let me get the definitions up. Take a look at what we have.
You don't have a definition of contractor.
No, we don't. But it could be.
I like it.
It's not this person with this what you're describing would be a commercial property employer. It's not. It could be an event center employer. Depending, that means an owner or operator of a privately owned structure. It's probably not an event structure either, or a hotel employer, and that's probably not a hotel employer either. So we are probably beyond what is being captured by this bill.
Okay, it's when you get back to it and look it over for the next hearing, it's in the bill 20-543. It's on page 2. It's on line. The commercial property employer paragraph beginning on line 19 mentions contractors and subcontractors. And I'm not questioning that. I'm asking about the practical, how that works, because they are not ever mentioned again. But in the course of penalties, in the course of anything, but they should be, because they're the people that are generally for in bills like this.
Thank you for pointing the language out and where it is in the bill. I see it now, and it would, because as long as we are regulating a commercial property employer and it includes a contractor, subcontractor, sublessee, it grabs those employees.
Yeah, but you're not. But this bill depends on a prior and a subsequent owner, a business, to create the situation in which things happen. They might be the same vendor they always were. If you would, I think this is a valuable part of the bill. It picks up people that usually get forgotten and left behind, like out at the ballpark, and the Orioles and all. And so it does the right thing. And I'm sorry, I don't mean to stop things. I think that we've got to make sure the language carries through, so we know that's clear and how it works in the law.
Councilwoman, let me take a look at that when we recess, and I'll get back to you on it.
Well, and to the whole committee, please. Okay.
And to the whole committee.
Yeah, thank you.
All right. Thank you. Sure, Councilman Stokes.
Thank you. It's probably for Victor, looking at the contract workers bill that was already passed. Isn't this almost about the same bill? Maybe we could have added it into the contract workers bill also, because you said it was the same bill. So I'm trying to understand why we have a separate bill, and we could have added what Councilman Burnett is saying to the previous bill that was already passed.
Yeah, there are slight differences between the two. This is, as I said earlier, it's a little broader. The employers that are being brought in under this protection are a little broader than what we had. As I said, in the Displaced Service Workers Act, we're just protecting building service workers and food service workers. Here we've got three different categories of employers and their employees that are being protected. Commercial property, event-centered employers, as well as hotel employers. So it's a little broader. And as I said earlier, there is overlap. There is a few little differences between the two. Under the event service, displaced service workers law, the employers are required to offer employees work beyond the 90 days as long as they've behaved themselves. This one simply says that the employer may offer employment to these people who are hold down for 90 days and beyond. So there's a little difference there. Could have been added to it, to the other one. I mean, that's, obviously the sponsor didn't think it was necessary or it was better to put it out. The other difference that I noticed here too is that the Wage Commission reports on the effectiveness of this bill after, in regard to the COVID-19 emergency. So it's possible that the Wage Commission at the end of a year will say that the bill is no longer necessary to protect in this particular time. Perhaps the emergency will be over, in which case it would come on back. It may be that the council would want to revisit the need for this particular bill. So there are some differences. They are similar, and maybe there is a way of combining the two in a single piece of legislation, just basically amend the original bill. But that wasn't my choice. That was the sponsor's choice, and I think that's where I'll leave that.
No, I wasn't blaming anybody. I was just trying to see. It was almost the bill was close, but you said there was some differences and overlap. So I just want to kind of be clear on that. Thank you.
All right, I'm gonna move on to our next department. Anyone here from HR?
Hi, yes, I am. This is Kimberly Humphrey.
Go ahead.
Come in. Hi. So we did not have anything substantial to add. We had recommendations on the other bill that we thought might have been up to date too. But for this one, we are deferring to legal and the Wage Commission.
Thank you. Anybody from the Wage Commission want to speak on this?
Apologies. Director Ray Parrott, Office of Equity and Civil Rights, which oversees the Wage Commission. We were in the wrong hearing, but we're in the right one now. Are we discussing 543 or 544?
430543.
Okay.
That's the employee retention.
So there were just a few things that we wanted to highlight. Section D with under 19-1, which is commercial property employees. Thought 25 was actually too high. When you think about Baltimore and you think about janitorial, security service employees, most of the have these type of individuals. They contract out for a different company. So, for instance, Redwood Street, which is I think Baltimore Development Corp owns this building. We might have one person that actually works maybe for BDC that is one of those types of individuals for security service. Everybody else is contracted out. So we have Admiral Security in this building for security service provider, Cushman and Wakefield building manager here, the maintenance, and the janitorial company is a Latin-owned company that comes in the evening to take care of the janitorial services. So none of them would count as an employee of the actual commercial property employer. So that's the case here. It's many commercial property buildings across the city that you're not going to have an entity that really has 25 employees that qualify under the definition of commercial property employer, having 25 or more janitorial, maintenance, or security service employees. They contract out for those services. So I can't really imagine who that would really apply to. I think with the hotel employers that may apply, but even with those, oftentimes they're contracting out for security. They may not be contracting out for maintenance, but they often also contract out for janitorial services as well. So they don't have to pay benefits that can be paid by another organization. So that might want to be revisited to kind of figure out exactly who's being targeted with the commercial property employer. Were there any questions about that before I moved on?
I do not. Anybody, any council members? No, you're good. You can move on.
Okay. The other was under 19-3, C, section, I guess, I, this is, says determines that fewer employees are required by the incumbent business employer. I feel like maybe there should be some kind of methodology that's included in this for that determination. So, I think like when you look down, it says conclusion of transition period. They require an evaluation and satisfactory evaluation. There's some kind of methodology to actually verify that the employer is letting someone go for some other reason. But when you go to determines that fewer employees are required, there's no methodology. So when they turn the business over to a new owner and the owner comes in and just says, well, I need fewer employees, I'm exempted from this, or that's my justification, there should be some kind of requirement that's in place for the owner to have to verify that, some kind of a business analysis or something that's done to say, look, I absolutely need fewer employees, and this is the economic analysis that I've taken to demonstrate that I need fewer employees. Most people are just going to take that route, whether they need fewer employees or not. So there should be some kind of verification in place of that. And lastly, under 19-10 penalties and fines, A1, which allows back pay for compensation but also interest on top of that back pay. We thought that was an excellent provision that was included. When we see our living and prevailing wage violations, we have cases for people who have been being paid incorrectly for 10, 15, 20 years, 7 years, 3 years, and all that's allowed under the code is for them to be, receive back pay. But in that time, the time value of money has completely changed, and they're not entitled to any interest under that. So we'd actually request that you all revisit the living and prevailing wage law for the city to amend that to include interest to be paid when a violation is determined to have occurred and a certain amount of time has passed by. Because again, sometimes it's decades that these people have been getting paid under the table and they're not entitled to any interest in the living and prevailing wage. So that's all I have.
Thank you. Any comments or questions from any of the committee members? No. And it doesn't look like I missed any other agencies. Councilwoman, go ahead. You're muted, Councilwoman, so we can't hear you.
Can you hear me now? You can?
Yes.
Mm-hmm.
Okay, it's just, okay. It brings us, I just want to say that this brings us back to the relationship between somebody who's working for a business that has gotten itself acquired as a direct employee or as a contract employee. And I was mistaken. The contract employees are mentioned again within the context. I just must have overlooked it before. But the issue that you're raising is a valid one about 25. In other words, so somehow this bill has to make it clear, it's already, the intent is there, that I don't know how to do this, but how you can count the contract people as a group. They are working for a company that's new. So somehow if we can make sure that that contract employees are part of this, which is the intent, and count and then subtract maybe for the direct employees to kind of compensate for the usual proportion of contract janitorial services and direct employment services in that function. I just think it's one of the things I would ask that we all look at and improve upon when we come back, as you have suggested, if everybody that's working in janitorial as a contract person, then there's not going to be enough, and there are just 3 direct employees, they're not going to be covered. And we got to make sure that at least the janitorial employees are covered in this. That's all. And thank you for raising it. It's tricky, and it's worth thinking about a lot. Thank you.
Thank you. If no one else from the committee wants to weigh in and speak, we'll go to public testimony.
I have a question.
Councilwoman.
Thank you, Madam Chair. Before we move to public testimony for the bill sponsor, Councilman Burnett, you stated that you would be offering up some amendments in the future. Are there any amendments that you're able to speak to right now that you're considering?
Yeah. So one of the things that was made clear is that it's not clear when this would end. And so we're looking at trying to figure out a more clear way to convey when this would sunset. I mean, it does mention a report out, which should trigger council action if it's deemed that through that review it's ineffective, or it needs to be extended out because it is become effective and maybe we need to do it more. I mean, it does mention that there needs to be a review and a study and an analysis of the outcomes of this. And so, but some of the feedback I've gotten is that it would still potentially exist in perpetuity as written, based on some interpretations of that. So I do want to make that more clear. So for all parties, so that it is clear to both us as a council when we would need to revisit this, and to the employers and employees, because the intention of this was to add, it was contextual, right? It was during the pandemic. We're trying to add some stability during the pandemic. And so we know that the pandemic began ahead of the full economic fallout from all of this. So we are trying to be able to make an argument that there does need to be a period of time that this is in effect for, and that at the end of that we should reevaluate. So trying to figure out, this is a long way of saying I'm trying to figure out an appropriate sunset, given the intention of this bill was not to be a long-term thing.
Thank you. That was my only question.
All right, we'll move to public testimony. And we have it up on the screen. So we'll move into that. If you're connected online, please use the raise hand function to indicate that you wish to testify. Each speaker must state their name prior to speaking. Users who call in cannot be identified by name and will be unmuted by the host one by one. If you do not wish to testify, just please say so when you're unmuted. Attendees will hear 2 beeps when they are unmuted. Please state your name at the beginning of your testimony. If a speaker is inaudible, they will be directed to call back or provide their testimony in the chat function. So we'll move on to public testimony and allow people to speak. So we'll do the people who called in, so you should be able to hear the beep and you'll be able to speak. Caller 1, you are unmuted. Nothing from caller 1? Caller 2, you are unmuted. Okay. Is that someone? You can speak, caller. No, they're not saying anything. Caller 3, you've been unmuted. Would you like to say
Hello,
anything? Hi, go ahead, state your name.
my name is Melissa Weller. I'm the law clerk for Frank Boston. We do not wish to testify. I'm just covering the hearing.
All right, thank you. We'll move on. Caller 4, you've been unmuted. Caller 4, do you have anything? All right, we'll move on to next caller.
Hello.
Caller 5. Hi, you've been unmuted. Go ahead and state your name.
Hello, can you hear me?
Yep, we can hear you. Just state your name and you can go right into your testimony.
Okay, my name is David Bruce. I work at the Renaissance Harbor Place Hotel in Baltimore. I've been working there for over 21 years as a banquet lead houseman. Since March 13th, 2020, I've been laid off due to the COVID-19 pandemic. While working there, I live paycheck to paycheck due to the wage I received from my hotel. You know, I woke up one morning and found out that I had no work or paycheck to rely on. To make matters worse, I spent up everything I had in my bank account to survive due to the fact that it took me several months to finally receive my unemployment benefit. I have many concerns that keep me up at night, such as my hotel has now been sold again to another hotel owner. My question is, will that new owner recall me back to work or will I be let go? And even if the owner does call me back to work, will I be receiving my same pay rate or will I be receiving pay as if I'm just out of high school? So please ask that this recall and retention bill be passed so that workers like myself will have a peace of mind knowing that after 21 years in the hospitality industry, I've earned job security. Without these bills being passed, I would be more likely to have to make a career change to support myself. Now, in these uncertain terms, let the recall and retention bill in order to bring relief to peace of mind to Baltimore hospitality workers and myself. Thank you.
Thank you, sir. We're going to move on to the next caller. Caller number 6. Are you there? Nothing from caller number 6. We'll move on to the next caller. Caller number 7. Is anyone there? Nothing. We'll move on to the next caller. Caller number 8. Are you there? We'll move on to the next caller. Nine, you're unmuted. Caller number 9, you're up. Nothing from 9. We can move on to the next caller. All right, doesn't look like we have any other callers on the line. We'll now move to
Madam Chair, someone just posted in the chat there are 3 individuals that look like they may be on the WebEx. Tracy Lingo, Tamara Mosley, and Vikis Mohayte. Apologies if I misstated your name, but that's what just popped up in the chat.
Kareem is next, and then we're going to move on to them.
Okay, perfect. Okay. Thank you.
Kareem, would you like to say anything?
Yes. Excuse me. Hi, my name is Kareem Boyd. I'm a worker at Camden Yards and the Baltimore Convention Center. And we were affected by the Displaced Worker Protection Act. And how I understand it, this bill doesn't actually force the employers to keep the people after 90 days. It just may. And I feel like it should keep them on the same way the Displaced Worker Protection Act, because I don't think it's any way that the companies are going to keep people after the 90 days are over if they don't have to. I mean, as long as you do your work and everything, the way the first bill was passed, the one from 2 years ago. That's all I wanted to say.
Thank you. We appreciate it. We'll now move on to the Tracy Langle. Tracy, are you here?
I am here. Can you hear me?
Yes.
Okay. Good afternoon, Councilwoman Sneed and members of the committee. My name is Tracy Lingo. I'm the staff director of Unite Here Local 7. We represent over 3,000 hotel, casino, food service, airport, and event center workers in Baltimore, including Kareem, and throughout the state of Maryland. The U.S. Bureau of Labor Statistics reports that pre-COVID, there were nearly 29,000 people employed in the hospitality industry in Baltimore City alone. Our industry has been extremely hard hit by the COVID-19 pandemic. 90% of our members are currently laid off due to COVID, from hotel banquet servers to university food service to Camden Yards workers like Kareem. And I would suspect that percentage holds true across the industry. While all of us are dealing with uncertainty during this pandemic, in worrying if you're going to be able to go back to the job you had before this crisis is not something that people should have to worry about. There are two situations in which hospitality workers are at risk in the current moment. One of them is the issue of recall of laid off employees, which will be addressed by the other council bill, the recall bill, which will be heard at a different date. The other situation is one that we're talking about here, the issue of retention, in which their place of employment is sold. Hotels, for example, and what all the panelists said is right. This really just expands on the Displaced Worker Protection Act and includes more commercial employers in that. I think hotels are a really good example of how this is a little bit different situation than the subcontracted workers that are covered by the Displaced Worker. Mary Pat, actually, our understanding of the Displaced Worker Protection Act is that it already covers contract workers in hotels or like at Camden Yards. So it actually does already cover the contracted workers. What we're trying to do is expand the protection to the direct employees. So for example, in hotels, hotels are often not owned by the brand that you see on the sign when you check in. Workers may be employed by Marriott or Hyatt, but the real estate of the hotel might be owned by a real estate investment trust or private equity firm or another business. Due to the economic crisis that's caused by COVID, we expect to see many sales of hotels in the coming years. And this goes to why I think the issue of the sunsetting of this bill is so important, because we don't expect the economic crisis in hospitality to end when the stay-at-home order ends. We think that the fallout of this crisis is going to go on for some time after that, and want to make sure that people are protected by the wave of sales that might happen. We have the example of the Renaissance Hotel where David works here in Baltimore. Employees were laid off in March and told they would be recalled in October. In the meantime, Sunstone, the REIT which owned the hotel and contracted Marriott to employ the workers, sold the hotel. The new owners contracted a different management company to employ the workers. And so workers, some of whom, like David, who have been there for over 20 years, have heard nothing from the new management company and are left wondering if they have a job to go back to. Even as hotels reopen, we expect that workers' jobs will continue to be in jeopardy as the economic fallout of this crisis continues. So today you're going to hear testimony from workers that are affected both by the retention issue and also by the recall issue. The COVID-19 employee retention bill will ensure that no worker loses their job as a result of the sale of their place of employment. Bills like this one have passed in other cities, and it is under consideration in still more cities and states. It simply extends the concept of the protection that is set forth in Baltimore's Displaced Worker Protection Act, passed in 2018. The city of Baltimore has invested heavily in supporting the hospitality industry and other large anchor institutions which fall under the commercial real estate provisions of this bill because of their promises of job creation. Working in hotels, stadiums, universities, and hospitals, workers in these places have stood by these employers for years, allowing these industries to be successful and serving the public. During this pandemic, workers in these industries have been among the many frontline workers we as a community have depended on. We should not need a law to ensure that employers will protect workers they have hired, trained, and depended on for years. And indeed, I think some responsible employers won't need this law to force them to do the right thing. But unfortunately, as we're seeing, we can't count on all employers to be responsible. And that's why we need to level the playing field by ensuring that all large employers do the right thing and stand by the workers that have stood by them. Tim, if you can, I'm happy to answer questions if people have questions, but The next folks on our panel were Tamara, Mosley, and Vikis Mohayte.
If Tamara wants to go, we're ready for her.
Can you hear me?
Yes.
Okay, good afternoon, and thank you for holding this hearing. My name is Tamara Mosley. Until March of this year, I feel like I can finally shed some light on the injustices that were faced upon like myself and my coworkers in such a time of uncertainty. We worry about our health, our safety, the health and safety of our children, and all other unknowns. The last thing we feel like we should have to worry about is our jobs that we were committed to before the pandemic. We were laid off due to this virus, and there's no reason why we shouldn't go back to our jobs once the virus subsides. So I moved to Baltimore City from New York in 2017. After becoming a single parent, I knew I had to find a city where I could gain gainful employment and good affordable housing for me and my two young children. With no job, no family upon arrival, like most single moms, I was forced to apply for government assistance to get on my feet. I made a goal for myself to let this period to be a stepping stone for me. I kept in mind that, I wanted to be successful. So I took these classes, hospitality training, and it gave me access to actually apply to the Residence Inn by Baltimore Marriott John Hopkins Medical Campus. When I received the job offer, you can't imagine, I was so excited. I knew that I would finally receive a stable income and a respectable establishment, as well as be able to, move forward with my dreams of being a good provider for my children and purchasing my own home. It was a new business, and I felt like it was a perfect fit. Not only had I had the chance to grow with the company, but I was there since day one. I was there since the ribbon cutting ceremony, all the way up until March 16th. So I was certain that since I was a great worker and a loyal employee, that I would be able to go back to my job once they reopened. But sadly, that hasn't happened. Even to this day, it's unclear to me whether I will be able to return back to my job. The business has been partially open for operations, but I still haven't gotten a call back. It means several things for me. First and foremost, my safety net is gone. And now it's a struggle to figure out how I take care of my children with no solid income. I was right in the middle of purchasing my own home when COVID hit. So now that put a stop to my loan process because I'm unemployed. Also, I have to start from the bottom. I got to start from the beginning all over again. And it's a mental strain. We just pleading with you today to honor the workers of this city by making sure we could keep our jobs. On behalf of myself, my children, my coworkers, and all hospitality workers, I just want to keep Baltimore City running and moving forward. And we asking that you all help us make this decision to move in the right direction. We understand that some things are out of our control, like COVID. However, some things we can control, and that's just to make sure our positions and our workplaces are there for us when we return to normalcy, whether it's the same owners or it's not. Thank you.
Thank you. Next, we're going to go to the last caller. Vikis, are you there?
Can you hear me?
Yes.
Hello, my name is Vikas Mohayte, and I work for Baltimore Marriott Waterfront. I've been working there for almost 5 years. Due to COVID-19 pandemic, I have been laid off since March 2020. This laid off has been affected me in many areas of my life. Financially, because I've been deploying my all the saving in order to save gonna happen. So insurance costs and other all things I don't want to blame hotel for closing due to COVID-19 pandemic, because we know it's a pandemic. No one can do anything about it. So including these layoff, we have to serve our company and welcome the guests to our city years now that we are in crisis. We should not worry about that my job at the risk. Job security is one of the most important thing I worry about right now. I'm concerned that the economic crisis caused by COVID-19 means that my hotel sells to another owner, and if that happens, there is no guarantee that the new owner would retain us. Even after the hotel opens, I worry that it would be very difficult to find another hotel job, because it's all hotel going through the same crisis. How would these hotels be able to hire me if there is no job or there's nothing? So this is why me and my fellow co-workers, I would like to support and retain this bill for hotel workers. Thank you so much.
Thank you so much for speaking out, and thank you for the work and the service that you give in Baltimore City. For many of the speakers who spoke today, we appreciate you. We know that you're the first face that many tourists see and many people see when they visit our hotels and restaurants. So thank you, and we're all in this together, so we'll definitely do what we can do. If anyone has any questions, please raise your hand, speak up now, because if not, because our Councilman Burnett wants to work on his amendments, we are, if not, going to go into recess, and we'll come back to do another kind of work session through this, so we can make sure that we cover all grounds and have the conversation. And so I'll say thank you for now. I don't see any hands. I don't see anyone jump in and say anything. All right, we're in recess. Thank you, guys. Thank you, everyone.